right, in prior proceedings, the defendant did enter a plea, and that plea had been accepted at the time of a change of plea based on the defendant's pleas of guilty and the findings of the court. It's a judgment of the court. Defendant is guilty of the following: count 1, first-degree murder, a class 1 felony and dangerous crime against children, committed January 20th, 2020. Count 2, first-degree murder, class 1 felony and dangerous crime against children, committed January 20th, 2020. That is victim B. Count 1 is victim A. Count 3, first-degree murder, a class 1 felony and dangerous crime against children, committed January 20th, 2020. Victim C. All are dangerous but non-repetitive offenses under the criminal code. In preparing for sentence, received and considered all of the following: the pre-sentence report, which includes some reference to victim next of kin, the requests in restitution amounts, the recommendation from pre-sentence report, which is in line with the stipulations of the parties in the plea agreement, the written separate statement by victim Ant in this matter, the defense sentencing memorandum and any attachments, the state's sentencing memorandum, the defendant's criminal history, which is non-existent prior to these offenses, as well as the stipulations of the parties in the plea. This is a stipulated specific sentence. Does the state have anything they wish to add for sentencing, or do next of kin wish to make a statement?
I don't believe anybody's going to make a statement today, Judge, so
Okay.
It's just going to be me. Before I make my statement, I do know...
Just pull a microphone.
Absolutely. Sure. There is a restitution request, Judge, for $30,000 from the MCAO Compensation Bureau, so I didn't know what the defense's position was on that.
Judge, we would request a hearing on that. We would like to see the receipts on that.
Okay, what I'll do is I'll retain jurisdiction, and then I won't set anything today. If you guys aren't able to work something out, I will set something at that point.
My only thing I would add, Judge, is we've provided all the documentation to the defense, and so I don't know if they haven't reviewed it. We did get some emails from Ms. Warner about it, so I thought they had reviewed that, but if they're not going to stipulate, then maybe we just set a hearing.
Okay, I mean, I'm happy to set a hearing today. It's going to be a little bit, because of my schedule currently, my Fridays are full, but so.
I understand.
That's fine, Judge, and Ms. Henry will waive her presence for the purpose of the hearing.
Okay, thank you.
Judge, I'm going to be brief because obviously we did file a sentencing memo and it is a stipulated sentence. I would note, Judge, for the court that it is probably hard to find somebody who had a role in this case who hasn't been affected by it. I would put obviously the family and friends in there. You read the letter from the victim's aunt talking about how this has affected her, how it's affected the children's father. Obviously, there's friends that have been affected by it. It has had an effect on the police officers and the fire and medical personnel who responded to that scene that day. A lot of the fire personnel thought, because there was a miscommunication, they thought it was a drowning call. They thought they were responding out to a scene to try to save children, and when they got there, found out that there were already 3 dead children inside of the house when they got there. I know the defense noted this in their sentencing memo. I think we noted it in ours. Some of the personnel, the first responders, are still in therapy and have been affected by what happened, even though this was 5 years ago. I would add attorneys to that list as somebody who himself responded out to the scene that day. Why this has had effect on so many people involved in this case isn't really a surprise. It's because the 3 victims, Zane, Mireya, and Catalaya, are 3 innocent children, all under the age of 4. The defendant is obviously going to prison for the rest of her life because she did the unthinkable in this case, Judge. She had a duty to protect her children from anyone or anything who would try to harm them. But unfortunately, in this case, she was that thing. These 3 children in this case were completely helpless to protect themselves from her, to stop her from what she did to them that day. And all 3 of these murders against Zane, Mireya, and Catalaya were senseless and, quite frankly, cruel. The defense noted in their sentencing memo that she is going to have to think about this and the effect that it's had for the rest of her life, and I hope she does, because she took the futures of 3 children away from them that day when she did what she did. In terms of the mitigation, Judge, I'm not going to touch much on it because I think the defense will articulate it better than I will today. I would note that the defendant, Ms. Henry, took responsibility for this when she admitted to the police what she did that day when they interviewed her, and she's obviously taken responsibility now when she entered into this plea agreement for natural life in prison. In terms of the other mitigation that's in the defense's sentencing memo, and I'm sure they'll talk a little bit about today, that is all information that our office took into consideration, Judge, when we made what was a very difficult decision in this case to come to this plea agreement and to not go forward, obviously, with the death penalty. Based on everything, Judge, we do believe that this plea agreement is in the interest of justice. We are asking the court to accept the stipulations in the plea agreement and sentence the defendant to 3 consecutive sentences of natural life in prison. And that is based on, obviously, the aggravating and the mitigating factors, Judge. That's all I have. Thank you.
All right, thank you. Mr. Tavazzoli?
Thank you, Judge. May I remain seated?
Yes.
For my comments? Thank you. First of all, I would like to express my deepest sympathies, condolences for the loss of Zane, Mireya, and Catalaya. They were so young and their lives were tragically taken from them. I'm personally deeply sorry for their loss, and Rachel is as well. This is a tragedy of monumental proportions, and we are here on this solemn day to give this tragedy a final resolution. Next, I would like to say that we believe the sentence in this case is appropriate. We can never bring back the lives of these 3 children, but Rachel is ready to begin to make up for this unfathomable loss of her children by spending the rest of her life in natural life in prison. It is no small sacrifice, but it is one that she's willingly and sorrowfully accepting as she's entered into the plea agreement. This begs the question, why did this happen? Ms. Warner and I have had this case for 5 years. In that time, we have explored different theories in the case and have concluded there were a variety of factors that led to this tragedy. And had any of these factors not occurred, it may have prevented the deaths of these children. There was strong evidence of postpartum depression, mood disorder, dissociation, severe depression, fetal alcohol spectrum disorder, and that can explain some of Rachel's mental state at the time. Her social history, much of which was provided to the court and is incorporated into the sentencing memo, is also another clear factor. And the complete lack of support that she experienced at the time of the offense is another factor, Judge. However, even though we've investigated this case, it is still kind of a mystery in the sense that we may never know exactly what was going on that day with Rachel, and Rachel can't explain it or remember it herself in any articulable way that can make sense to herself and to everyone else. It's important to note that this is an explanation for these horrible offenses and not an excuse. In no way does it justify what she's done. For those people that have only a fraction of the information about her case in the media, not knowing anything about who she is, and who have tried to capitalize on her case, I would like to say that she will be punished for the rest of her life. Not only will she be imprisoned and given no chance to get out, but she will live with the knowledge of the gravity of her offenses and must live without the loving presence of her children for the rest of her life. It's also important to note that up to the time of their deaths, Rachel was always described as a loving mother. In the time that we have represented her, she's always been kind and thoughtful, providing us all with origami figures she's made for us, me and my staff. Equally important is the fact that in the 5 years that she's been in the Estrella jail, which can be is described as kind of a junior high school on steroids, she hasn't received one ticket for misbehaving, and that's nothing short of a miracle in there, Judge. Especially with Rachel being diminutive, she's an easy target for bullies and other negative behavior that's directed toward her, particularly in light of the charges. Like I said, the sentencing memo that we provided to the court covers the vast majority of her mitigation, so I won't revisit those in these remarks. I do want to say that I do believe Rachel has accepted her responsibility and her fate, and she's ready to go to prison and try to be a positive influence in that world, even though it's going to be a restricted life that she's going to lead. And finally, I'd like to thank Chris and Jesse from the Maricopa County Attorney's Office and Catherine Ferguson Gilbert, who was on the case before, for helping us to resolve this case in a very appropriate way. I think they were very fair and professional in the course of our relations with them. I also want to acknowledge, as Mr. Sammons has said, that there were a lot of first responders that were affected by this case, severely traumatized. Finally, I'd like to acknowledge that because it affected the law enforcement, not only, I think Chris kind of mentioned this, but everybody was affected by this case. Law enforcement, the firefighters, even your court staff, this court, our defense team and the attorneys, the county attorney's office, everybody who's touched this case has been affected by it. We're forever changed by the deaths of these children, and life will never be the same for those, for the lives that their lives have touched. So with all that said, Judge, we ask that the court follow the recommendation in the plea agreement and sentence Rachel Henry to 3 consecutive natural life sentences. Thank you.
Okay, thank you. Ms. Henry, is there anything you wish to say?
No, Judge.
Oh, okay. Any legal cause?
No, Judge.
All right. Let me get a hearing on the restitution first, and then I'll pronounce sentence. How long is the hearing itself going to take, if it goes, do you think? An hour at most?
An hour at the most, Judge.
So April 25 is, well, hold on a second. I'm sorry, I could do April 4 at 11 o'clock. That works.
That works for us.
Let me double check my calendar. Your
Sure.
Honor. It's always on the slide. That's fine, Your Honor. Thank you.
Okay.
Yeah, that's good,
All
Judge.
right, and obviously if there's an agreement to something, we can vacate that. So it's ordered setting a restitution hearing April 4th at 11 o'clock. Ms. Henry's presence will be waived.
Thank you, Judge.
Okay. All right, the court has considered now the statements of all the parties. There's not much more this court can add. This is obviously one of the more horrific cases that this court has ever had before it. The court, however, greatly appreciates both memorandums from the parties, especially, frankly, I guess, the defense memorandum that adds context to, doesn't explain anything, but adds context to perhaps what leads up to something like this. The court also agrees that the resolution in this matter is a just resolution, and that the state, in dropping the notice of death with the plea agreement in the decision-making, came to a very just decision in doing so. As to counts 1, 2, and 3, then the court finds that probation is not appropriate. The court finds, based on the fact of the dropping of the notice of death, there's only one sentence that may be imposed on each count. It's therefore the judgment of the court as follows. As to count 1, imposition of sentence, defendant is sentenced to a term in the Department of Corrections for a term of natural life to begin today's date. I will give credit on count 1, which is 1,852 days of credit. As to count 2, it's ordered the defendant be imprisoned in the Arizona Department of Corrections for a term of natural life that should be deferred, Monica. All right. With 0 days credit. As to count 3, defendant to be sentenced to the Arizona Department of Corrections for a term of natural life with 0 days credit. It is ordered that count 3 shall run consecutive to count 2, and count 2 shall run consecutive to count 1. The court notes first that the plea calls for consecutive sentences, and the court is following the plea agreement. Secondly, the court also finds that each victim deserves to be recognized as an individual victim, and consecutive counts are therefore warranted to consider the impact, obviously, on each victim from Ms. Henry's actions. Therefore, the consecutive sentences are warranted in this matter. The court will retain jurisdiction over restitution on count 1 for a period of 5 years, waives the defendant's appearance. Financials to be imposed on count 1, beginning today's date, a $20 time payment via $20 probation assessment, $13 criminal assessment, victim rights of $9 and $2. It is ordered dismissing counts and allegations in paragraph 3 with defendant to undergo DNA testing for law enforcement purposes. Ms. Henry, because you did plead guilty, you do have the right to petition the court for post-conviction relief and have a lawyer represent you. If you can't afford a lawyer, one will be appointed to you. If you can't afford copies of the necessary records and transcripts, they'll also be provided to you at no cost. If you want to petition for post-conviction relief, you'll file a notice within 90 days of today, or you lose the right to seek that relief. You understand that the conviction suspends your civil rights, including your right to vote, serve as a juror, hold public office, and firearm rights. Actually, let me back up. You're going to sign in a little bit for a copy of your post-conviction relief rights. You'll leave us a fingerprint, have the ability to apply to set aside any convictions as provided by law. Again, the convictions suspend any civil rights, including right to vote, serve as a juror, hold public office, and firearm rights. You may apply at some point to have civil rights restored. The granting of that will be at the discretion of the court. It will not apply to restoration of firearm rights if convicted of a dangerous or a serious offense. You may also be able to petition the court for an order sealing all records of your arrest, conviction, and sentence related to the offense. If I didn't already say so, it is further ordered that a copy of the order of confinement, together with all pre-sentence reports, probation violation reports, medical and psychological reports not sealed, are remitted to the Arizona Department of Corrections. It's order remanding the defendant to the custody of the Arizona Department of Corrections to begin her sentence today, with all other orders not specifically stated reduced to writing. Is there anything else from the state?
No, Judge.
Any else from the defense?
Yes, Judge, there's one other thing. Ms. Henry, because she didn't have a prior criminal history, she voted in the last election, and as a result, she's been called for jury duty in March. So we would ask that the court maybe, if you could vacate that for her.
I don't know procedurally how I could do that. Let me follow up with the jury commissioner to make sure, though, that she's taken off any list.
Thank you, Judge.
Okay. All right. Anything else?
No, Judge, that's
Okay.
it.
So I think we'll take Ms. Henry out, and then she will return sometime later to sign all her paperwork.
Thank you.
Okay. Thank you. Is it all good to sign? Okay. Okay. Thank you.